Okay, guys, we do have another filing in Idaho for the state of Idaho versus Bryan Kohberger. As you can see here, it has the date May 2nd at 5 o'clock p.m. So we did cover, this was right after this most recent hearing, which we did cover on our most recent live stream for the state of Idaho versus Bryan Kohberger coverage. I will, in case you missed that, I will go ahead and have that included here on screen for that video of the hearing. And I'm also going to make sure I've got a link here for the playlist for the coverage we've been doing of state of Idaho versus Bryan Kohberger. So that way, if you haven't yet been caught up to speed, you'll have that opportunity. I'll make sure that these are also in the description of this video as well. So where we were at, just like a quick summary here, is prior to this May 2nd hearing, the prosecution had submitted some motions for these upcoming hearings regarding the defendant's fourth and fifth motions to compel. They had made a motion at the end of April. They had made a motion for the hearing to be closed to the public. And so, as is typical with the way things are done here in Idaho, all of these different filings are done, are submitted in writing, and then oftentimes, as we see there, then later argued in a hearing. So there's a lot of activity in general. So they submitted that motion, and then of course that included a follow-up scheduling order so that they could then come and talk about it. So that's what happened on May 2nd. They came and they talked about it. So it would seem that timing-wise, and we talked a little bit about it, but the filing of the prosecution to close those hearings was submitted very soon after the fallout, if you will, of the hearings regarding the jury surveys and the prosecutor Santa, as he's lovingly been nicknamed, or just Santa for short, Bill Thompson. There had been some back and forth with him and the defense's expert. It was quite a spicy hearing, to say the least. And so part of what kind of came out of that, right, was the defense was saying to the prosecution essentially that, well, we're allowed to, if we're defining public record, even if we go by the most restrictive definition of public record, which would be, anything that is part of the public court record, right? Even if we use that definition, what they were saying is, well, the vast majority of the contents contained in the survey come from that. And then, of course, he kind of, in a way, I don't want to say blamed, but he was saying that the vast majority came from the PCA, probable cause affidavit, which Prosecutor Santa, when he had that first big press conference, came out and encouraged the public, as in public people, to read for themselves. Of course, his intentions were hoping to minimize maybe misinformation, speculation. Obviously, he had good intentions, right? With the probable cause affidavit, people deserve to know. But he was just making a point that the prosecutor himself disseminated, if you will, public record, as in court record, to the public and encouraged people to read it for themselves. So the other thing was that it was also stated that everything that is then said in the hearings, right? So as we know, what happened was Prosecutor Santa was reading some of the questions in the hearing, and then because of that, they are then transcribed, and now that is part of the public court record. I think what happened, at least in my opinion, is, the state wanting to, they immediately reacted, right, like to close these hearings. And it would make sense if one of the reasons was just kind of like, sparring, like maybe they're feeling a little bit salty because they're like, well, if what you're saying is that anything that we talk about in these hearings is now going to come up in a jury survey, potential jury pool survey, if that's how it's going to be, then fine. I mean, I don't know. That could just be one angle to it, right? Because a lot of this is strategy. It's sort of like this going back and forth, as we have seen. Now, are there other reasons? Of course, we know what they said, right, in the hearing, but part of what was really interesting was the lady who, I actually don't know her name, but she was speaking for or rather arguing for the prosecution. She kept kind of going back to her main motivation for wanting these hearings to be closed was to protect the right to a fair trial. And I think a couple times she said the right to a public trial, and then she corrected herself and said and changed it to fair trial. And I commented on it when we were listening to the hearing because I thought it was really funny, because I'm like, wait a second, this is weird, because that's Bryan Kohberger's right. Why is the prosecution arguing, like, of course they're supposed to want him to have a fair trial, but like, it was weird because it was like they were using his Sixth Amendment, and it just didn't. And then towards the end of the hearing, Ann Taylor actually said the same thing. She was like, they're trying to essentially like hide behind, or the way I would say it, like misappropriate, if you will, his Sixth Amendment right as like their reasoning for wanting the hearing to be closed to the public. And the other thing that was interesting was this female prosecutor, she didn't actually, whenever she kept saying, protect a right to the fair trial or public trial when she misspoke, what have you, like, she actually wasn't really specifying who she was referring to, but I inferred it to mean Bryan Kohberger, as did Ann Taylor. And why is that? Well, because the state does not have a right, has no rights. That's not a state's right. That's the defendant's right. There's no constitutional right for the state to have a fair trial. So I assumed, and as did Ann Taylor, that she had to be referring to Bryan Kohberger, because who else could she be referring to? All of that to say is that's setting the stage for something I found interesting as I just glanced over the first paragraph of this and decided to do a video on it. So here we have, this essentially, what this is going to be showing us here is the state's motion was granted. So, the defense was arguing in the hearing that they wanted it to be open. The prosecution wanted it closed. And Judge, if you will, sided with the prosecution. And as you can see here, it says, order granting the state's motion to close the hearing on May 14th. For the reasons articulated on the record during the May 2nd, 2024 hearing, the court orders the hearing on defendant's fourth and fifth motions to compel, set for May 14th, 2024, be sealed to protect the parties. Bam, right here, parties' right to a fair trial. So that is that's why I was giving all that preamble, if you will. Whoa, look at that. Because parties, plural, and possessive. And it'll be interesting to see what else is said about this, because that is very interesting. So it's almost like Judge is trying to, like, be careful about. Again, it was weird the way she said it in the hearing, the female prosecutor, because she didn't specify who she was referring to. But the only reasonable conclusion was she had to be referring to Bryan Kohberger's rights. So I don't know if this is him just trying to be careful because she didn't actually specify. I don't know. But it is interesting because only one party has a right to a fair trial in this proceeding. So, yeah. During the hearing, it is anticipated that the parties will discuss specific items of discovery that may or may not be admissible at trial. The disclosure of such evidence to the public at this stage of the case is not appropriate and may prejudice the jury pool. So he's essentially, falling back here on the non-dissemination order, basically, that to use that, as a reason. Essentially, he's kind of. I feel like the prosecution could have argued this angle and didn't. If they did at all, for me, it got lost in just how many times they kept repeating the whole party's right to I'm quoting Judge there. Let me quote the right person. She kept saying the right to a public trial or a right to a fair trial, and she didn't specify. And that's what I just kept taking away from it because it was repeated so many times. And this is a stronger argument here, actually, that, discussing the evidence here that may or may not be admissible, the topic of these motions to compel, that it could prejudice the jury pool. So that is, again, the point of the non-dissemination order. And as we've learned, anything that happens in a public hearing is now being disseminated to the public because it is part of the court record. So real quick, let's pop on over to here, this is the order allowing the defense to continue their surveys. I already have it pulled up here to the relevant portion, but we're going to look at how Judge, just as a refresher, decides to use, which definition to use for public record. So here it says the defense argued that the questions in the survey were based on information obtained by defense expert Bryan from reading and watching various news articles and broadcasts from both mainstream media and social media. The defense further argued that the questions did not violate the non-dissemination order because they constituted, quote, information contained in the public record, end quote. The defense argued that the, quote, public record, end quote, encompasses all information, let me repeat that, encompasses all information in the media for the public's consumption. Which makes sense, right? Like if you're thinking about what's going to potentially taint a jury pool, anything in the media, right? Where it's difficult is that the court can only control what they can control, right? And this is what I was just referring to with the part about Prosecutor Santa. So the questions at issue were, again, discussed, including the fact that some of the questions on the survey are not rooted in fact or supported by admissible evidence, but are simply rumors in the media and on social media, while other questions were formulated based on information from the public probable cause affidavit filed by the state. There we go. After a lengthy hearing, the parties were made at odds over whether the 9 questions at issue should be asked. The court now orders the following. The public record, as that term used in the non-dissemination order, means the public court record, i.e. information from public hearings and from documents filed in the case that are not sealed. So that's what I wanted to get to there, because when you look at this, so now that that's what they're working with and this has been defined, you can see how the state could be possibly reacting to this, because it's like, well, okay, public hearings, right? And like also they got kind of called out for maybe contributing to people's knowledge of the case, even if it's accurate, right? And I think also the defense was arguing too that, of course, some of the information in the PCA would bias the jury pool by its very nature. Okay, let's go back to here. So, all right. So further, the parties have stipulated that all attachments to discovery requests and responses be filed under seal pursuant to Idaho Court Administrative Rule 32. Now, here's what is interesting. So I pulled this up too. If you guys remember, when the Prosecutor Santa, made this motion, here it is, I pulled it back up, motion to close hearings pursuant to ICAR, Idaho Court Administrative Rule, they cited 32G. And we went through all of this on the live stream from whenever that was. I will make sure I have it popped up here on the screen. But we went through and read this entire rule and went through 32G. And I picked out from among it, there were a bunch of different options as to what you could use to support your argument. And I picked out what I thought maybe would be relevant, just for fun, basically, right? For that particular rule, and if what they might be referring to, they being the prosecution. So that's what they were relying on, and that's what they argued. And here it is here, 32G. Now here is what is also interesting when I pull this back up. This is from Judge again. He's not citing 32G, because I was like excited to see if maybe I just by chance guessed correctly which portions of 32G were going to be relevant. Apparently none of them, because he is citing, Judge is basing his ruling on ICAR 32I, subsection 2D and E. So, and then this here where it says IC and then it has that funny symbol, that means that's from the Idaho code. So that's a statute. So we have a rule and we have a statute. But let's see what he's saying here. So, because 1, the documents contain facts or statements that might threaten or endanger the life or safety of individuals. 2, it is necessary to preserve the right to a fair trial. And 3, disclosure would constitute an unwarranted invasion of personal privacy. So I'm going to see if I can find for you guys, let's see if we can find ICAR 32I2D, since it's different from what we had read before. Okay, so here is ICAR 32G, which we had gone over before. And again, this is what the prosecution cited in their motion to close the hearing as the basis. So they cited this rule 32G. And again, it was really long. We went through all this. So we're going to scroll down It has, I think, 29 sections. Yep. Okay, so there's the last one. So now we have H. Now we're looking for I. Here it is. So again, Judge is basing his ruling on 32 I, 2, D, and E. So let's go to subsection 2. Here we go. And then we need D and E. All right, so D, that the documents or materials contain facts or statements that might threaten or endanger the life or safety of individuals, or E, that it is necessary to temporarily seal or redact the documents or materials to preserve the right to a fair trial. So that was exactly what he cited in his ruling, Idaho Court Administrative Rule 32 I, 2, subsections D and E. So what's interesting is that it's like he's kind of in a way correcting all the mistakes of the prosecution, because already, in my opinion, I'm seeing two major things. That they should have cited potentially this as the reason for their motion, because the basis for their motion is not what he's granting this order on. Like, he's not granting it based on that. He's almost in a way correcting it and saying, here's what you should have actually cited. But then also, as we said earlier, so it's like the first thing he did was he almost corrected their oral argument from the hearing, right? Like I said, because they kept talking about a fair trial, public trial, and again, if they did mention anything about prejudicing the jury pool, that was missed. That was missed, in my opinion, because of how many times they kept reiterating the trial, the fair trial. But this would have been a better oral argument if they'd focused on the non-dissemination element of it. And then again, as far as their written motion, they apparently cited a rule that he didn't think was very applicable. So he corrected that as well, and included a statute, which I don't think they included anything from the Idaho Code, the prosecution, in their original. We can actually check and see. Did they? Let's see, make sure. Yep, just 32G. They didn't. So he's, wow, that's, you guys see what I'm saying? It's interesting. He's granting their order, but for completely different reasons, essentially, in my interpretation, based on the written motion and also the hearing. So yeah, okay. The hearing on May 14th, 2024 will deal directly with various attachments to discovery requests and responses that are sealed. If issues arise that should not be sealed and should be addressed at a public hearing, the court will hold a separate open hearing at a future date to ensure the victims' families have prior notice and an opportunity to be present at any open hearing. The hearing on May 14th, 2024 will not at any time be open to the public to ensure the victims' families are afforded every right under Article 1, Section 22 of the Idaho Constitution. So that's a nice looking signature. So basically, that's all we have now. I keep checking to see if there's been anything else filed, and I think in the past couple of days, this was the only new filing, so that's why I wanted to go ahead and just make this video. But I'm sure we'll have something else for you guys soon. But that is all for now. See you guys on the next video.